As part of your proxy statement filed with the SEC, you will include a beneficial ownership table that discloses those that beneficially own more than 5% of a company's voting securities today on Zippy Point. I'm Brock Romack, and I'm a big fan of yous. So before I bring Roland Kelly on, using his in-house perspective, his in-house lens, to explain how to fill out this beneficial ownership table in more detail, let's run down some of the basics. Purpose. Why does the SEC even require that this information be disclosed? It provides shareholders with an easy-to-understand snapshot of any concentrated holdings of a company's voting securities. That's the purpose. By knowing who the company's largest shareholders are, other investors are better able to gauge whether they want to invest in this company, as well as evaluate the likelihood of a change of control. The legal requirements under Item 6D of Schedule 14A, companies are required to provide a beneficial ownership table in their proxies, which is incorporated by reference into the Form 10-K under Item 12 of that form. There are two beneficial ownership tables. There's this one, and then there's a separate one for directors and officers, executive officers ownership, and I discuss that in a separate Vid-Guide, a link to which is below. Occasionally, these two tables are combined into one in a proxy, and that's permitted, but typically they're broken apart and even in different sections of the proxy in terms of their location. Item 403A of Regulation SK is the regulation that spells out what the table looks like and what it requires. It requires disclosure of those that beneficially own more than 5% of the company's voting securities. And the number of securities listed in this table must include the right to acquire beneficial ownership of any securities within 60 days, 2 months. For this calculation, you'll be following Rule 13D3, the beneficial ownership rule. Instruction 4 to Item 403 gives the company the option of indicating the source and date of such information. This is important because this is often third-party information, shareholders outside of the company. Almost all companies footnote the source and date of the information for each of these owners, not just when there might be an inaccuracy. So each 5% owner will be tagged with a footnote indicating where the company obtained the information, their diligence, in order to fill out the table. Under Instruction 3 to Item 403, companies are deemed to have knowledge of any Schedules 13Ds and Schedules 13Gs, and also check the Schedule 13Fs filed with the SEC. So clearly a company's diligence has to go as far as checking the SEC's EDGAR database for these filings. And here you can see a few examples. The other part of Instruction 3 to Item 403 is important too, that if the company knows or has reason to believe that such information is not complete or accurate, or that a statement or amendment should have been filed and was not. There often is a disclaimer to this table to reflect this. We only know what was made public limitation as part of the introduction or as a footnote to the table. Location, where in the proxy can you find this table? It varies since Item 6D of Schedule 14A doesn't dictate its placement. It's mostly found in the middle or towards the back of the proxy. In fact, the caption for this table varies. It's not a specific mandated caption. It might be securities ownership by certain holders. It might just simply be stock ownership. It might be voting securities and principal holders. It varies quite a bit. You can modify the table a little bit in Item 403. A form of the table is specifically provided. That's the format you should use. The format should not be varied too much from what is in Item 403. You are permitted to add additional columns to provide additional information. But that doesn't happen too often with this table compared to the other beneficial ownership table with the directors and officers. And even then, it doesn't happen that much. People use the footnotes. So let's talk about the footnotes. There will be at least one footnote for each 5% or greater owner in the table, disclosing where the information was gleaned from, a Schedule 13D, a Schedule 13G. Another universal footnote is whether the owner has sole voting and dispositive power, as noted in Instruction 2 to Item 403. This disclosure is permitted to be made via a column as well, but most companies use footnotes to accomplish this. Which 5% owners get included in the table? Under Item 403A, any person, including any group, as that term is used in Section 13D3 of the Exchange Act, who is known to the company to be the beneficial owner of more than 5% of any class of the company's voting securities. A company's 401k plan should be listed in this beneficial ownership table, assuming it holds more than 5% of a company's stock, only if the plan trustee has the power to vote or dispose which usually isn't the case because the plan participants typically have that power. That's why you might see different approaches taken by different companies because their 401k plans might be different. Their voting and disposal powers might be different. And now I'm going to bring Roland on. Our guest today is someone that I've known for a couple of decades, Roland Kelly. He's been in-house for over 20 years, having recently made a switch to Velocity Financial to serve as their general counsel and corporate secretary after a long career at Jefferies Financial Group, where he served as the right hand to the general counsel with the title of managing director, associate general counsel, and assistant secretary. Roland has a unique background because Jefferies also had some major subsidiaries, one of which Roland served as the de facto chief legal officer and chief compliance officer. I'm Brock Romanek, today on Zippy Point.
Quick Zips by Zippy Point.
Quick and dirty. So Roland, for this beneficial ownership table, what determination date do you use for your calculations?
This one's a little bit different than beneficial ownership table for officers and directors, although I always use the same determination date. But the information that you have access to isn't going to necessarily reflect that date. Because for 5% owners, you really are looking to Edgar, the SEC, you're looking at the Schedule 13Ds and the Schedule 13Gs, and those are typically filed by February 14th. And they reflect year-end holdings as well as February 14th holdings, or the date that they're filed for the 13Ds, for instance. And so for that information, it's going to reflect at the latest February 14th, which is the filing date for the D and the G, even though your beneficial ownership table may be April 1st. So you're using a numerator from February 14th with a denominator of April 1st. Unless you actually go in and call up the owner and ask them if they want to, do a bring down, if you will, of their ownership, or if you can look through 13F filings, F as in Frank, if you really want to scope those out. If you're that familiar with the process and how 13F works, you can determine it from there as well.
So what's required when you do the math here to be included in the numerators and denominators? I guess so the numerator you're told by looking at a 5% holder's filing. That's one way to find out.
Yeah, so you'll look at the 13D or the 13G, and that'll give you the numerator. Then you also look into their disclosure to see whether or not they're including any options or warrants or convertible instruments. If they are, then you have to make sure you include that into the denominator, which your denominator you start off with is the number of shares outstanding as of the date that you're providing, and then add into the denominator any of those shares that haven't been issued, like I said, that are like options or convertible instruments.
And what, going back to diligence, let's talk about disclosure controls. Do you document your process?
And if I'm only using the Schedule 13Ds or 13Gs, then really there's no documentation other than a footnote to the beneficial ownership table saying that the information has been gathered from a 13D or G filed with the SEC on this particular date. If I have reached out or if I've parsed through 13Fs and gotten additional information, then I will document that.
All right, so you get your 13Ds and your 13Gs together, and then you go and look at the 13Fs that might be filed after those. There are a little bit of apples and oranges in terms of the information in there. How hard is it to tell how much of that 13F information is useful to you?
It's really only when there's been a dramatic change and you talk to the actual shareholder. Because like you said, it's a little bit different. You don't always know the names under the 13F of their affiliates that are filing. So, and sometimes, there may be a de minimis amount for a particular affiliate that's not included. So you do have to be careful. And so my practice has been to always, unless you're having a conversation with the shareholder, is just go with what they've disclosed in the 13D or 13G, or if they're a 10% holder, the Section 16 reports filed on Form 4.
See how this is done. So this is from Matson's proxy statement. And says it's based on the most recent reports that they filed with the SEC. You got the first and technically the first two columns of this table, the name and the owner right here together. I think that's pretty typical to not footnote the address. You include it right underneath the name. And then you have the ownership and the percent of the class. And then, if you don't mind, let's talk about the footnotes for a minute. What should these look like? They have, this has a fair number of footnotes. And you could tell here it's got, each one breaks its different types of voting and investment, I guess, dispositive power that these holders have. Let's look at another example here. This is Pfizer. So in these footnotes, what do you like to put?
In the footnotes, again, it's directly held shares, indirectly held shares, sole voting power, shared voting power, sold investment power, shared investment power. It's all information that's required to be disclosed in the 13G or the 13D, as well as number of shares that they have a right to acquire within 30 days or 60 days, such as options, warrants, convertible instruments. And then if multiple entities are listed, sometimes Vanguard Group, for instance, might have different entities listed. You may want to include some of the different entities as well. It just depends on what they've disclosed in their 13G or 13D.
And I see this, Pfizer has baked their disclaimer basically into their intro here. The only persons or entities known to us to be a beneficial owner are as follows, but sometimes you see a disclaimer where it says, to our knowledge, this would be in the footnote, to our knowledge, except as noted above, no person or entity is a beneficial owner of more than 5% of our voting power. So I think, if you somehow miss and omit a 5% owner, that's probably because they haven't filed a 13D or G as they're supposed to. And if you don't happen to know all your holders that are over 5% and you miss someone, I don't think the SEC would necessarily go after you. But again, if they've made those filings, they'll be in your reporting stream. And so you got to be doing that diligence up until the date you file. Schedule 13G is not due until 45 days after the calendar year. So that's always on Valentine's Day. And so, you don't want to, if you're a 1231 company, you got to make sure you're doing these calculations after Valentine's Day, or else that's tantamount to malpractice. In my opinion, you're not doing your diligence. If somehow you provide some information that's a little bit misleading and the 5% owner gets mad at you, it's going to be an innocent error, I'm sure. It shouldn't result in liability, but that's not good for shareholder relations.
Absolutely. And it's always good to, be in contact with whoever it is at the company has the relationships with the shareholders, because they can be a valuable resource as well.
So where does this table fall on the fun scale for you on a scale of 1 to 10?
This isn't quite as interesting because it's really just pulling filings and reading filings and then regurgitating the information. So this is more of a 5.
5's very good. So I'll give a personal thank you, Roland. You were one of the first people I've talked to about even my idea for this new venture, and you've been so supportive, and this is one of the first tapings I'm making. So I appreciate it.
Well, it's been my pleasure, Brock. Thank you very much for inviting me.